Life on the Level here in Oakby, Leicestershire. We're just about to go into our first guest speaker, who is Toni Robinson, HR expert, walking encyclopedia on employment law. What she doesn't know isn't worth knowing. And the reason for Toni giving this presentation today, we want to shed some light on employment law relative to people working with a balanced condition. So I am going to shut up, hand over the microphone and let Toni dive into this. So thank you very much, Toni. Over to you.
Thank you. No. Good morning. Someone's fiddling with my thing. It's not working. There you go. Good morning, everyone. Hi. So my name's Toni Robinson. A little bit about me. I've been working in HR and employment law for, I want to say 5 years, but it's 20. So it sort of makes me feel really old. I want to thank you for letting me come here today and try and at least shed a little light on the condition that you have and how that affects you if you are in employment, and what you can expect an employer to do for you, and what happens if, you know, they don't really. I am mainly respondent based, so I work for employers. So my business, Nucleus HR, works for employers, very rarely works for employees, if at all, really. However, what I can do is share with you the employer's side of it and what we should be doing to help you, and then we can treat that as a minimum for you. Is that okay? So I thought what we could do today in this session is we could look at disability, we could look at what it actually is and where the definition is. Because in employment law, it's slightly different to sort of out there on the street. It is slightly different. We're going to look at the employer's duties, so what can you expect an employer to do? And then I want to really just open it up to you to ask me as many questions as you want, so then it becomes a lot more relevant for you today. But first I'm going to sort of do a little bit of a questionnaire. I'm looking at you and I just need to know, could you raise your hands for me if you are in employment today? So if you are an employee. Okay, excellent. Thank you. And how many of you are concerned about your employment today as a result of the condition? Okay, cool. Okay, right, no pressure on me then. What I'll do then is I'll give you an overview, and for anyone that's got questions at any point, if it's not made sense to you, just put your hand up and I'll try and clarify anything I can for you. If you've got any questions, shout them out, you know, please do, and I'll try my very best to answer them for you. If you've got sort of a complex, in-depth issue that you'd like advice on, I might struggle to answer that in the time we've got now, but I'll happily try and guide you after today. Is that okay? Any questions so far? Excellent. So, a disability in employment is classified, this is protected through the Equality Act, and it was originally brought in through the Disability Discrimination Act in 1995, but it got kind of eaten up into the Equality Act in 2010. And the definition of disability is a physical or mental impairment which has a substantial and long-term adverse effect on a person's ability to carry out normal day-to-day activities. That's nice and subjective, isn't it? Nobody's got a clue what that actually means and whether you're disabled or not. See, the interesting thing for me is who decides if you're disabled under the meaning of the Act? Because actually, it's not you, it's not me, it's not your employer, it's not even your doctor, it's not your consultant. Technically, to find out whether you're disabled under the meaning of the Act, it's a judge. So if you go to court, it's the judge that will tell you whether you're disabled or not. But where does he take that from? He takes it from the statute, the legislation that we look at. And we'll get guidance from all the medical professionals and everything. But ultimately, he makes the decision, firstly, whether you're disabled, and secondly, whether or not you've been discriminated against on the grounds of your disability. So, if I can share with you a little bit about what that means. So what do we look at? How do we define disabled? How will a judge look at it? How will the legal profession look at it to decide whether you're disabled or not in employment terms? So what they tend to do is when they talk about substantial, more than minor or trivial. So in that case, it has to last or is likely to last in excess of 12 months. So most of you here, I've only really dealt with maybe a couple of cases of balance conditions on an employee level. Okay, we've dealt with it in an employer level, but on an employee level. And I know that majority of these cases last in excess of 12 months. I'm getting a lot of nods. They last. Okay. So, substantial long-term adverse effect on your normal day-to-day activities. Most of your balance conditions are going to be classed as a disability under the meaning of the Act in law. Most of them are. The other thing they'll look at, there is a World Health Organisation's encyclopedia of conditions. They'll look at whether it falls into that too. So if you've got a condition that falls into that will also be considered. They'll look at many things to decide whether or not you are disabled in employment terms. Does anyone know the penalty if you are discriminated against in employment financially? Okay. If you believe that you have been discriminated against, either directly or indirectly, by the fact that your employer has not complied with his obligations or her obligations, the actual award is unlimited. So an unfair dismissal is normally capped at around a year's salary or £90,000. Actually, disability discrimination, any of the discriminations, is unlimited. So the financial penalty against an employer very often can go to hundreds of thousands of pounds. So it's in every employer's best interest not to let that happen. So the incentive for me, when I talk to employers and say, right, okay, you've got an employee, yes, they appear to be disabled under the meaning of the Act, we've looked at what their condition is, we've looked at all of these things. The incentive for them to do the right thing is not just engagement, it's not just about retaining talent in the workforce. Actually, there's a massive financial penalty if they don't treat you properly and they don't treat you in accordance with the law. So for me, there's several reasons why an employer should do the right thing. But if you've got a condition that you need to go to your employer with and say, look, I might need your help here, what can you reasonably expect him to do? It sounds like you've had a great experience with your employer, but not everybody gets that support and that level of support. In fact, for every one like you, I probably spoke to 9 that haven't had that support. So for me, what's an employer, what would I tell an employer to do is probably the best way I can look at it. And I always tell an employer that they have a duty to make a reasonable adjustment. That's what the Equality Act is about. Essentially, if you are disabled under the meaning of the Act, they have a duty to make reasonable adjustments in the workplace so that you, as a disabled worker, have the same access to everything that is involved in doing your job and being in the workplace as somebody who is non-disabled. So they have to make those adjustments for you. There is a difficulty, because what we need to understand is what's reasonable. So they've got a duty to make a reasonable adjustment. But what's reasonable? Does anyone know the definition of reasonable? I love this. It took judges days to figure this out, and it's took me years to try and make sense of it. But reasonable is what the average man on the top of a double-decker bus would see as reasonable. I don't know what the average man is, I don't know what the double-decker bus has to do with anything, but the judges thought that would be the best way to describe it. Reasonable. So reasonable is, for me, what's to be expected. Is it reasonable that you work for a small employer who has 5 people, 2 floors, and you want him to put a lift in? That might not be considered reasonable. Is it reasonable that you can work on the ground floor and then move the team downstairs? Absolutely, it's reasonable. It's about finding that compromise to make sure that actually there will normally be a reasonable answer to how we can support you in the workplace. There will normally be something there if the employer wants to. So the difficulty is always exploring what reasonable is. I do remember one case I had where they actually did ask that they employ a support worker full-time for the member of staff, so that they had somebody around them the whole time. So that would have been another salary every year to support the other person there. And unfortunately, that was considered not reasonable. But what happens if it's not reasonable? What do we do to help you stay in employment? It's difficult. It's a little tricky. So what's an employer likely to do? Because if they don't know the answer, because they're not medically qualified, they don't know your condition inside out, what are they likely to do with them for you? Well, if it was me, and you came to me and said, I've got a condition, it's causing me some problems in the workplace, I'm nervous about what's going to happen in the future, I need to work, I need to keep my job. What can we do to help? The first thing I'm going to do, I'm going to ask for access to your medical records. Okay? Because I'm not medically qualified. I don't know enough to be able to help you. But I know that there's medical people out there that will be able to tell me more about the condition you're going through, the impact that has on your day-to-day life, how, if I sent a job description of yours, how your condition will impact and the job will impact on your condition. I've got a duty of care as an employer for you. So it's important that I find out medically how I am best to support you. So the first thing I would do, if you came to me and said that, doesn't matter if you're off sick, it doesn't matter if you're at work, if you said that to me, I would want to be able to support you. So there is a piece of legislation called Access to Medical Reports Act 1988, and that means that you get, I can ask you to have access to your medical records through a medical professional. You have a certain set of rights that go with that. So you have a right to refuse my request to access your records, and you can absolutely go, I don't want to, okay? The difficulty with that is if you refuse your employer consent, they then can make a decision on the information that is available. And that could be that they go, well, I don't know how best to support you. I don't know how I'm supposed to make any adjustments for you and whether or not actually I'm doing the best for you. And under my duty of care, if I thought I was putting you at risk, even if I made adjustments, I'd be really worried about that. I wouldn't want that for you. So you'd have to think about whether you want to give consent or you don't. But if you don't, and your employer can make a decision on the information available, they may choose to say that actually one of the outcomes could be, yes, hi.
Can you give partial consent?
Well, in what way?
Repeat that for the stream.
Sorry, what's your name?
John.
John just asked whether or not you can give partial consent. In what way do you mean partial?
In terms of allowing access to some of your medical records, but some conditions which are not relevant that you don't want to disclose.
Yeah. It is absolutely right, that you're absolutely right. It doesn't go back into your whole history. If you fell over at the age of 5 and broke your leg, we won't know about it. We will only know about the condition that you have come to the employer with and said, I've got a bit of an issue right now. It will only be relevant to that. So whether it's a balance condition, whether, you know, stress or anxiety, if that is the problem, any of that, we'd only look into that specific issue. We wouldn't have the right to have any other. Sorry, you're quite right though, thank you. So the issue of giving consent, it would be a huge invasion of your privacy if we looked at all of your records. They will only give us relevant information to the condition that you've got now, currently. So the next thing, so if you said no and you declined consent, they could actually say, as an employer, we don't believe. You know, they'd go through a process to invite you to a meeting, but they could end up, that process could end up terminating your employment on the grounds of incapacity and the fact that they don't believe you can remain in employment. So often it is best that you give consent, because there is another thing that happens further down the line. So sometimes they'll go direct to your GP, sometimes they'll go direct to your specialist, so the person that's been working with you. Sometimes they even go straight to an occupational health doctor who is specialised in designing adjustments in your workplace. So they may choose to go to any individual specialist medical professional. At that point, you do have another set of rights as well. Well, at any point, you have a set of rights which says you can, you go and see them. Once the report's made, you have the right to see that report before anybody else. So before it goes to your employer, you have the right to see it. There's a couple of things with that. You then can say, well, is this accurate? Is this factually accurate? And if it isn't, you've got the right to have that amended. So the specialist, if he agrees or she agrees, they can amend that report for you because it's then factually accurate. If they don't agree with you and say, well, actually, we don't see it that way, okay, they can refuse to amend it, but they will put your comments alongside it, at the back of it, etc. So it will be noted that you don't either agree or you've got a different opinion of this. At that point, you will be asked as to whether or not you want that report released. So you could still say no then. So your initial consent that you gave then, at the beginning, you could actually still retract it if you wanted to after you've seen the report. Still do it. So it's not really the end of the world if you said yes and then changed your mind. But if you saw the report and then thought, not sure how this is going to help me, you could choose to say no. However, we do go back to the point where the employer has tried to get some information about your condition and how he's going to help you. And it could be that we end up sort of sitting there going, well, we're not medically qualified, how do we protect you? So back to square one. So there's a good employer will actually, when you sign your consent to have access to your records or to go and see a medical professional, a good employer will give you your rights. All of my letters that I give to employers will give you, and there's about 8 specific rights, and they'll explain it all to you in that letter. If you are ever asked for that and you are concerned, there is a huge amount of information out there that is available for you so that you understand specifically what you are entitled to. But ultimately, the employer will need that information. And it is supposed to be designed to protect you and to support you and to work with you. Do appreciate it doesn't always work like that. I do know of a few cases where it's been used in a negative way. And that report, and I will go through that now if you like. So at this point, so the reports come into the employer, which is what normally happens, and they will arrange to meet you. Good employer, where actually they go, do you know what, there's a way of dealing with this, let's make some adjustments, let's look at what we can do, let's get specialists into your workplace and let's look at what we can do. Actually, we need to change the lighting for you, let's just see how that works. You might need a specific lamp, so let's get that for you. Actually, all this needs is a different screen, we can do that for you. All of those things should come through this medical report and getting people in to help you. And that meeting, when you first look into the medical report, is where that should happen. Unfortunately, that's not always the case. So, and I'm seeing a few nods around, so I'm guessing that unfortunately that's not always the case. And what is more, it's becoming more common. And I know why, because employers see the support of employing somebody with a disability as a cost. And they don't see it as actually retention of talent, retention of somebody who is loyal and engaged to the business. And actually, would probably give 10% above and beyond everybody else for the support that's given. So they get that discretionary effort and they release it. They just don't see it that way. When I work with employers, I do try and get them to see it that way, but not all of them do. So what happens then? So that meeting that you're invited to becomes a little bit more contentious. So it doesn't always go down the positive route of let's look at how we can retain you and how we can make adjustments to the job and the workplace. What they can do is say, well actually, these adjustments aren't reasonable. And actually, we'd be failing in our duty of care to allow you to remain. We don't want to put you on the ground floor. We can't move all of marketing to the ground floor and all of finance upstairs. Probably can. But they'll argue not. Okay? And then it gets to the point where they, unfortunately, can, sorry, I get carried away with chatting and forget there's a thing there, so sorry. See, told you, I get carried away. So what can happen in that situation is they could decide to terminate your employment on the grounds of incapacity. So you'll have had an accident, you'll have been given a copy of the report. Sometimes, and I do know employers that do this, they will look at using a commercial sort of occupational health doctor, and the doctor will say, this person is never likely to render good service for you in the future. That gives an employer pretty much the green light to be able to terminate on the grounds of incapacity. If they did that, you would be entitled to your notice pay, whatever contractually you're entitled to, but equally, which is no less than 1 week for every year of service up to a maximum of 12 weeks. But it could be contractually you're entitled to more. But ultimately that is what an employer might be able to do. What you have is the right of appeal, because everybody has the right to appeal. And that's where it gets a little bit more complicated for you. Because that's where it goes, well actually, how far do I take this? Do I go and get a second report? Do I appeal with different medical grounds? Do I appeal with, an occupational health consultant who comes along and says, these are all the things that you could do to make sure that these guys can stay in employment? And if you did all of that, and they still said no. I mean, they could say yes and overturn the decision and bring you back and do all those lovely things. Equally, they could say no. So what happens then? Well, then you have a decision to make. Because coping with everything you're coping with anyway, which is hard enough when you are diagnosed with the conditions that I've seen. A good friend of mine, sorry RuPaul, a good friend of mine, RuPaul, I'm sure you all know RuPaul, she's all but famous. Is it famous or infamous? I'm never quite sure here. You know, I saw RuPaul go through her condition, and actually it's horrendous to watch somebody go through this. And then you have to make a decision of, actually, do I just want to go, I want to get on with my life, there'll be more than one way for me to earn a living. Actually, I know I'm good at what I do, I know I'm valuable, I know that I apply good service to an employer, and you know what, I'm going to take my services and I'm going to give them to somebody else and move on. And allow you to concentrate on your condition, perfectly entitled to do that. Or do you go, you know what, I am going to stand up for myself here. And the route then is very much a legal one. So ACAS to go through their process, which is an early conciliation process in the first instance, to try and work with the employer to some kind of resolution, which could be that they take you back. More often it's a financial settlement. Now, everyone's got the right to do that. And from a disability discrimination point of view, there is no qualifying length of service. So you could be there, not being rude, 6 weeks, less actually. Pre-employment, you are protected in any of the discrimination family tree, because there's lots of them now. You are protected pre-employment. You go for an interview and you are protected. So you don't need to have a qualifying length of service, and you could make that application to a tribunal. Going through ACAS, there is certainly an awful lot of support out there for you. The one thing I'll always say, and I myself have been through an employment issue personally, and bearing in mind I've got 20 years of employment law experience behind me, even I went, I'm not sure I've got the energy for this. And I'm going to say medically fit, but I'm sure there's a lot of people in my life that would say, no, she's not. So, I would say it takes an awful lot out of you. And when you've just gone through a process where you've had your employment terminated, actually to go through the process, which can take a year, from start of the ACAS conciliation right the way through to a hearing, which for discrimination these days is more likely to be 5 days in a courtroom, is debilitating. It's exhausting. I'm not saying don't do it, I'm saying go into it with your eyes wide open. But you'd have the right to do that. If you felt that you'd been discriminated against because your employer hadn't made reasonable adjustments, hadn't had discriminated against you, hadn't actually followed any of this process and just went, don't think you can work for us anymore. In fact, one of my clients, I'm going to roll my eyes, and you're not going to see it on the video, but I'm going to roll my eyes. He phoned me this week and said, oh, I'm ever so sorry. He said, I meant to ring you last week. I've got a guy that's been diagnosed with epilepsy. I went, oh no, that's really sad. He went, yeah, so, you know, I told him HR said he can't work here anymore, so, you know, no problem. And I went, sorry, what? He went, oh yeah, it's all right, because he can't climb ladders, can he? Sorry, when did you become medically qualified? Because I thought you were a window fitter. So I'm a little bit confused. And he went, oh no, he definitely can't stay, can he? It's ridiculous. And I went, no, there is a process to go through. At that point, he'd already discriminated against him, and I was backtracking for him. And employers might not even go through any process at all because they just don't know. And until they take advice, they just don't know. So I would say today, I've sort of said, look, what's your employer likely to do? Well, if they're taking advice, they're likely to do any one of those combinations. They could also do what my client did this week. And at that point, your world falls apart and you go, oh, what do I do? But it could all happen because, unfortunately, employers don't always know what they're doing. And you don't know what you don't know. So, all I can say is, if you are struggling with employment, pick up the phone to somebody, take a little bit of advice, try and get your employer to see, because a lot of it will be naivety, a lot of it will be ignorance from your employer's point of view. Encourage them to get advice. You know, if you work for a small employer, they will have advice lines available to them more often than not. Ask them to pick up the phone to it and say, look, can you just double check it for me? Because I'm not sure this is quite right. As soon as they know what the penalties are, they'll start to behave slightly differently. Because if that alone is not enough to scare an employer to go, maybe I should treat Andrea better. Don't know who Andrea is. Is there an Andrea? But I think we should, you know, try and work with your employer to get them to see the fact that you have actually got rights and they've got obligations. The more we can do that, the better off we're going to be. Has anyone got any questions at this point? Hi.
Yeah. Do these rights not...
Bear with me. RuPaul's going roaming.
I'm not allowed for this, too late. Okay, no, it's all right. I'm just wondering if these rights and obligations apply to 0-hour contracts.
Yes.
Now, I've got a contract that says that they're not under any obligation to offer me hours.
Mm-hmm.
So at the moment, I fill in an availability sheet. They can offer me so many shifts a month.
Yeah.
If many years rears its ugly head again, and I think, well, you know, I need to go on sick or whatever, they could just go down the route, presumably, of saying, well, we're not going to offer you any hours. That's it. So they're not actually terminating my contract. Yeah. But they're just saying, well, we're not going to offer you any hours, and well, how would I get around that?
Yeah. 0 hours it's an amazing piece of legislation, that. And if the government hadn't have Brexit hadn't got in the way, 0 hours would have had a whole new piece, it would have had an overhaul. Because that was all supposed to happen pre-Brexit, and then Brexit came along and they went, yeah, we're going to leave that for a little while because we're a bit busy over here. Yes, so as a 0 hours, you are an employee. So you're not a worker, you are an employee. So you are protected from discrimination law and the the Equality Act and disability discrimination specifically, you are protected from that. So if you can, and the likelihood is you can, and you know, reasonable belief, reasonable evidence, you don't have to specifically out and out have to have evidence, you know, written down somewhere that, is it Gary? Gary, you know, Gary told me about this condition and then suddenly, you know, Gary didn't get offered any work. The court is likely to believe that actually they didn't follow due process in order to get to that decision. Although they will go, well, it's 0 hours, we could refuse to do that. The likelihood is they'll find that you potentially were discriminated against on the grounds of your disability because they failed to offer you work. Is that okay?
Yeah, that's fine, thank you.
Have we got any other questions? Have we got any questions on Facebook?
There's a gentleman over there as well.
Can we do one question on Facebook and then I'll come back to you?
It's actually a question for myself rather than Facebook.
Okay, sorry. She jumped the queue then.
Have you got any advice for kind of how to deal with the aftermath of all of this? So in terms of you've been through the different steps that you've outlined today, and you know you still, the resolution that you've had at the end is you're not doing the job that you were doing and things like that. Because I sat here listening to your presentation, and I found it really difficult because it's something that I've gone through really recently. So it's just useful to kind of know the aftermath, how to deal with it.
In terms of actually, you've gone the part where perhaps the employment has ended, or you've just been put into a different department, or the job's changed, which
Ended.
Ooh. See, that's really difficult because it's actually if you're going through a condition as well. So you actually have got ill health, and it's not the greatest condition to have to deal with a set of stress, really. And it is very stressful to do this. I'm going to move this way. I saw your face.
Yeah.
So the best thing I can do is to say, first of all, continue with any treatment that you can continue to have. Have a good support network around you. Take advice. Kevin will have my details. Now, I can't technically give specific employment advice to individuals because I'm a respondent-based company, but I can signpost you. So I can absolutely go, look, yes, go to ACAS, of course, they are very, very good, but there are also other people that I can signpost you to. So if you get my details from Kevin, I'd be quite happy, and that goes for Facebook viewers as well. If you get my details from Kevin, I'd be quite happy to go, look, this is pretty much where I would direct you to. If you tell me a little bit about what's gone on, I can direct you to the right person so that you can get some advice moving forward. When did it happen?
Last couple of years.
Right, okay. There is a time limit, that's the reason I ask, because if you were to go down a litigation route, there is a specific time limit, and if it's in the last couple of years, it's a little bit more difficult to do anything from a litigation point of view. Not impossible, because the time limits stretch if you've got a specific reason, but not that far, to be honest. So we can't do anything from that point of view, but if it's more about actually how do we get you back in employment, how do we get you back to do things like, you know, get the job, get sort of, even if it's part-time, and actually try and get your way back in. I've got some ideas of how you might want to do that. And I can actually coach you on that separately, and that's not a problem, I'll do that for you.
Cool.
Is that all right?
Yeah, brilliant.
Okay, I've got a question over here. I've got a couple of questions that I will put to you very shortly, but I'm not going to jump. I'm not going to queue jump. Okay.
Hi, it's Tim. We have a situation about three and a half years ago where we were going through the balance challenge, waiting for diagnosis, being very ill, absent from work. As an employer, they have a process of going through various sections for return to work.
Yeah.
But at the time, we were unfit to go back to work because we were still going through the diagnosis process, etc., etc. But the employer continued along this escalation of phases 1, 2, 3, and then it got to the point where we felt we were railroaded into an all health retirement situation, which we took because we've got, you know, like everybody, you've got bills to pay and all those sorts of things to consider. But afterwards, you question yourself, particularly when you took listening to yourself saying, should we have gone on that route? And actually about if it's 2 years down the road now, so we're probably a little bit far out for that.
Yeah.
But actually, do you know what? If it was still wrong, then other people should know about it and maybe look at a different way to pursue it.
Yeah, you are right. The process that you went through was an absence management process, and there would be an absence management procedure, which is normally less used for long-term health issues. It's normally used for the sporadic absences where typically it's sort of, Johnny didn't come in today, he's got a bad leg. Johnny didn't come in on Friday, he's got a cough and cold. When you have a long-term adverse effect, they typically use a slightly different process, which is your medical reports, and they are due. Did you get that, all of that?
Yeah, we did that.
Right,
Yeah.
okay. And on the medical report, did they?
They didn't request access to medical reports. We had 3 separate occupational health diagnoses.
Okay, but were they independently done? Yes.
Yes.
Yeah. Okay. And without seeing it specifically, it could be that they absolutely did an incapacity sort of thing dressed up as an ill health, because actually it could be that those reports supported the employer. Did any of them give sort of reasonable adjustments and advice on that?
No.
Okay. Okay, it looks as though that might have been a little bit unusual, because normally they do give advice on, look, if you were to retain them, this is what you'd normally do. The lady behind's going, no, that didn't happen for me either. Unfortunately, there are a lot of employers that use commercial occupational health doctors actually just to get to the point where they go, they're not fit to render service for you anymore. And that's all they're looking for. Okay. Sorry.
Any other questions in the room? Yeah. I think this is making my blood boil, and I know
No,
that
it's
people in this sort of
frustrating.
situation are probably feeling exactly the same. People who've either had to give up work through no fault of their own. It's really, really difficult.
The only thing I can say, that I would like to say, is for every person that I know that has gone through any situation similar to this, they've actually come out the other side being better off, working for a better employer eventually, earning more money, having more control over their life, and actually enjoying life a lot more. So sometimes it does actually work out so much better, and we'll get you there. We'll definitely get you there.
Can I ask a really quick question before? But why is it that employers seem to be so ignorant when it comes to a lot of the disability law and what they should be providing and how they should be helping their employees? Why is it that employers are not aware of these laws?
See, I don't think sometimes it's ignorance. I think sometimes it's fear. I think having disabled people in the workplace, I think employers are fearful of it because of the financial penalties and because of the risks of actually I'm not, and there are, and I'm not saying there's any in this room at all because that's so unfair, but there are employees that go around looking for claims. So employers have just got so fearful that they're going to end up with a £400,000 claim, and by the time, and their business be ruined, and it's fear. I genuinely think it's fear. And whilst I don't think it's right, I absolutely would stand here today and go, look, you deserve better, everybody deserves better. I think it's fear, not altogether ignorance.
Sorry, I interrupted your question, Kim.
Right, hi. And in my job there's 4 different parts to it. Recently I've been told I've got to do the one part that makes me dizzy. Is that reasonable? Because the other 3 jobs I can do perfectly. There is a lot of us work there, so it's not like they're losing out. The job would be done by somebody else.
Okay.
We move around every hour.
Okay, how much percentage of the other jobs can you do?
I can do 3 of the 4.
And is it sort of a 25% split? So it's sort of, so you're doing 75% of the other work, it's just 25% you can't do?
Yeah.
And is it, and have we had any medical information that's been given to the employer about that?
Yeah, well, they asked the doctor's records
Yeah.
a long while ago.
And have you been
Some bosses are all right,
Yeah.
and then other bosses, like the one I've got now, isn't. She says, no, you work here, you've got to do the job.
Right. I would encourage them to have another look at it.
Yeah.
Is the best way I can say that without going into a huge amount of advice
Yeah.
on that.
Mm.
It sounds to me that probably needs to have another look at it.
Yeah, okay, thank you. Thank you.
Other questions?
Is there anyone else?
Yeah.
Oh, hello.
I don't want to agree with you, I've already had one question, but if an employer decides to downsize his workforce
Yeah.
and they just happen to pull your name out of the hat, knowing that you've got a medical problem,
Yeah.
is there any way you can get around that?
Well, an employer in a redundancy scenario, in a true redundancy scenario, so often employers have been known to look at this slightly differently and go, well, actually, if I can't manage the absence because I'm scared of it, I can't manage the ill health, I'm going to create a redundancy scenario. But, you know, ill health isn't, redundancy isn't a vehicle to address ill health. So what they would normally do is they'd have a scoring matrix. So they'd put all the people that they could, so say there's 30 of you, just for argument's sake, or 10 of you that do that job, all 10 go into the matrix, all of it gets scored, and you look at sort of several different criterias. They'll look at disciplinary record, they'll look at competence in the job, and they'll have to objectively score that. So it wouldn't just, no, your absence record is taken into account, but anything that is classed as a disability under the meaning of the Act should actually be removed. So actually, they shouldn't do that, and if they have done that, and we can prove it's been done that way, then that would be, again, something that you would be directly discriminated against because of your condition.
Just explain that again.
Oh, hello, sorry.
Sorry, just
All
explain
of
that
it.
again. So you're talking about people's sickness levels,
Yeah.
you know, because that's a concern for a lot of people.
Yeah, so if you were in a redundancy scenario, which actually it always happens, you know, I'm doing one next week for another employer, what they will do is there's always a pool of people. There's very rarely a pool of one. So it's very rare that you'll be on your own being made redundant. There is normally a group that could be selected from. So there could be that they're making 2 redundancies out of 10 people. In order to do that, they would look at a selection, lots of criteria, and they would judge you all, score you all on that criteria. So it could be length of service, less so these days because of age discrimination, but it will be things like specific competency in the job, it will be disciplinary record. They will use absence. They will absolutely use it as one of the scoring mechanisms. But really, any absence that is connected to a disability is normally removed and should be encouraged to be removed, because if not, you're facing a direct discrimination because you've been off sick because you are disabled. So they remove that, and it's really more the sporadic absences. So yeah, Johnny, I don't know who Johnny is, I'm sorry if there's a Johnny in the room, but Johnny didn't come into work on Monday, he was hungover. Johnny didn't come into work on Friday, he sneezed. Those are the absences that are judged in that scoring criteria. So the ones with the highest score remains, and the ones with the lowest scores are the ones that are made redundant normally. So your absence really, from a disability point of view, shouldn't really be taken into account at all. Is that okay?
Thank you.
Any other questions today? If anyone's a little bit shyer and they've sort of gone, I don't really want to share this, just email Kevin and he's just going to forward them on to me over the next week. So please do. I'd be more than happy to sort of guide you in the best way I can. Thank you very much for having me today. I hope everything goes all well for you guys, and I hope it all gets better for you and you are treated fairly and reasonably. But thank you very much for having me.
For that, I think you'll all see we're just at the tip of the iceberg there. There's so much discrimination going on. Anecdotally, what I've seen, for every one case, and I've only seen one with Andy, of great behaviour, I've heard of so many employers just trying to get rid of people. So anyone out there, by the way, on Facebook, we will be encouraging our members and anyone to send in their own stories. They can be anonymous where there's been discrimination. It's not about picking on employers, it's about educating them, and it's about letting you and anyone else out there with a balance condition understand what your rights are. I think the simple message, brilliant what Tony's told us, first thing I'd be telling any employer is, did you know there's unlimited damages if we don't get this right? Because that, I think, sadly, is what a lot of employers understand, money. But it's just amazing. I'm so glad we did it, Tony. I'm so glad you've come and given us that time. This is just the beginning, and this is only one part of our work, but I think it's so important. It's bad enough living with a life-limiting condition. What you just don't need is to be discriminated against and face losing your income. So thanks once again, brilliant work, thank you. And as you heard Tony say, if you've got any questions, get hold of me and we'll pass the details on to you. We're just going to leave Facebook now for a 10-15 minute break, and then we're back for part 2 with our next guest speaker. So see you soon. Thank you very much.